Hi, I'm John Counsell. I'm a senior reporter with Texas Lawyer newspaper, and welcome to the October 17th, 2008 edition of Reversed and Remanded. My guest today is Russ Roden. Russ is a former judge and current partner in Addison's Nesbitt, Vassar, McCown, and Roden. And I'm going to talk to Russ today about a couple of pretty hot appellate issues that are going to have a big effect on litigators in Texas. And Russ was a long-time civil defense lawyer before he became a judge. And you're kind of in mediation now, right, Russ?
Doing mediations, arbitrations, but also still handling a pretty healthy trial and appellate docket.
Okay, so this may affect your life here pretty soon. Russ, this week before the Texas Supreme Court, we had re-argument in a case called Entergy. And this case has drawn a massive amount of attention because of its effect on workers' comp law, and something nobody really thought would happen was that the Supreme Court would make a ruling that would sort of shut off a theory of liability and a way to get into the court, and that's whether or not general contractors, whether or not a premises owner can be a general contractor. Okay, and I guess the huge issue here is legislative intent. We've got legislators that are saying, look, you guys have completely ignored what we meant to do with workers' comp law. We've never provided immunity for premises owners. In fact, we've rejected numerous times proposed legislation that would do exactly that. So our intent is clear. So we had that background in front of the Supreme Court. So my question for you is, man, with so much attention, what is the chance that the Supreme Court is going to reverse a 9-0 ruling that they had last year on this case?
Well, let's make no mistake about it. The fact is that it's hard to get a single trial judge to reverse themselves on a motion for reconsideration.
Yeah.
So with a 9-0 decision, it does seem like that would be very difficult. But one thing you have to realize is there's a reason why rehearing was granted on this.
Yeah.
There was a tremendous amount of briefing that was done on behalf of amicus briefs being filed on behalf of various entities, including, I believe, the Texas Trial Lawyers and the Texas Defense Council, that filed these briefs, and I think that has brought to the attention of the court that they've got a real issue here that they need to revisit. Another thing to keep in mind is under the internal operating procedures of the Supreme Court, at least 5 judges justices would have to agree to have that reheard.
Yeah.
And so there is something within the court that's moving. So is it an impossibility? It's certainly difficult to ever get a 9-0 decision overruled. But with that, I think that you've got a lot of interest that's in there. I think it's coming from the amicus, and I think they realize, or there's the potential by the argument, that we're talking about a scheme that was made based on the employer-employee relationship within there, and that expanding that in the premises context, as has been pointed out, may be a complete shift in what we've looked at as far as the traditional workers' comp scheme.
Yeah, yeah.
And so I think they realize obviously there's an issue just by the vote to get it back in. Okay.
Second big appellate issue we had this week is a case called N. Ray Volkswagen. That was a en banc decision from the 5th Circuit on a mandamus case out of the Eastern District of Texas, and it was a products liability case that arguably happened in Dallas, but they filed in Marshall. This went up this circuit a couple of times, and they ruled that the trial court judge abused his discretion in keeping the case in Marshall. Now this case has got a lot of attention because a lot of people like to file there. Russ, is that going to affect people's practices? Is it going to make it to where it's easier for the defense to get out of the Eastern District?
Well, I certainly think that one thing that it has done, especially in the concept of a case such as this, as a products case, which is Judge King pointed out in the dissent, in a products case where the situs might not be within the jurisdiction that it's filed or the venue that it's filed. In those type of cases, if you don't have situs and you don't have the party in there, I think you've got the real possibility now that the 5th Circuit has said plaintiff's choice, and one thing they clearly have said is, unlike in a forum nonconvenience argument, the plaintiff's choice is not going to be given the deference that I think people have traditionally given it. It is less obviously in a 1404A and always has been. I don't think that's new. But basically, I think the court is saying here that if you can show there's a more convenient forum, a more convenient venue, let me say, than the one that is there, if the plaintiff can't show, or if it's not shown that the venue is as convenient as the one that's being selected as the transferring one, then I think it really sends a signal that it's going to be harder for somebody to keep their venue.
Right.
I do think that we will be seeing a lot more of challenges by the defendant on the venue, and I think it also means we're going to be seeing more extracted litigation on mandamuses.
Let me ask you, on the flip side of that, do you think plaintiffs are going to be less inclined to file in the Eastern District if it's going to be easier for them to be moved out?
Well, I don't know that they would be less inclined to file there, and obviously I don't think this is a case that says you don't have a chance here. It's a matter of still having to look at the factors, and I think one thing that counsel need to consider when they look at this opinion is that prior times when mandamus was used in cases, the real issue there was, did the court consider factors that weren't supposed to be considered or not consider factors that should have been considered? Here, the dissent, as they point out, says the trial judge considered all the appropriate factors. The majority is just taking a different weighing or viewing of that, and that shouldn't rise to the level of abuse of discretion.
Yeah.
And the majority disagreed, so that's going to be something to really look at.
All right, it's now time to put Russ in what I like to call the witness stand. I'm going to ask him some ridiculous questions and see what he has to say. All right, Russ, first one. Have you ever used the phrase, "That's the stupidest argument I've ever heard," while mediating a case?
Not verbally.
Okay, what's the safer bet now, Russ? Playing the lottery or playing your 401k?
I definitely am all for the lottery.
Okay.
I think the lottery's good.
That's a complete inside thing, and if you know Russ, you know what I'm talking about. All right, Russ, I have been playing the 401k, and I now plan on retiring at the age of 97. Can I borrow $5?
Well, I've got 5 in my pocket. I'll give it to you. No problem whatsoever.
How about 10?
I think you're starting to push it.
Okay. Thanks, Russ.
You bet.
Bye-bye.